Rise to speak in support of the amendments tabled by the Honourable Trevor Mallard, and in particular to amend Clause 2 by omitting all the words after force and inserting the words 1 April 2012, and to insert a new Clause 2A. This Act expires on the close of 8 November 2010. And these amendments go to the issue of timing. And I want to put before the Chamber some related issues of timing. And I'd like the public to hear this sequence of events, because it's quite important, sir. Thursday, the 14th of this month, Jerry Brownlee convened a meeting attended by SPADA, MIA, CTU and himself. A press release was issued after that meeting outlining that they had found a way forward, that a deal had been done. Sir, on timing, the next day, Sunday the 17th, of this month, the Screen Actors Guild decided to lift the boycott. I say that again, the timing was Sunday the 17th of this month. The boycott was to be lifted. However, I've cited emails which make clear that Warner Brothers requested that the press release not be issued until Peter Jackson had had an opportunity to comment. Fair enough request. That's Sunday the 17th of this month. On Monday the 18th, Mr Jackson, the Warners, SPADA, all knew on timing, sir. No. Monday the 18th, timing, Monday the 18th of this month, sir.
I'm standing. This is about the commencement date of the introduction of the bill. It's not about timing related to the introduction of the bill, but not a sequence of what's happened over the last few weeks. So bring it back. Honourable David Cunliffe.
Thank you, Mr Chairman, and I'm trying to explain the reasons why I'm supporting new Clause 2A, calling for the expiry on...
Point of order. I hate to do this to my colleague, but the Clause 2A debate is a separate debate. It is the next debate.
You're right. Thank you. Clause 2, commencement.
I appreciate my colleague's comment, and of course he'll recall that in my opening comments I supported two of his amendments very generously, both that one and the previous one, 1 April 2012. Okay, so on timing, here is the kicker. Here is the kicker. The boycott was to be lifted on Sunday the 17th, but on Wednesday the 20th.
Order. Look, I've just mentioned to the member, this is about the commencement. It's a very narrow debate. It's not about what's happened in the past. It's about the commencement and introduction of this bill for the royal assent. It's a very narrow. The scope of this is a very narrow debate. And I'll ask the member to confine his comments to the commencement date, not a sequel of events that has happened. That's out of order.
Point of order, Mr Speaker.
Point of order, Honourable.
In the previous contribution from my colleague, the Honourable Trevor Mallard, he raised the issue of whether...
I decide I decide the relevance of the content of the speech. The member hasn't mentioned the title once. The member is talking about timing. It's a timing of the sequel events. That's what's out of order, and I ask the member to come back to the commencement date. That's what Clause 2 is about. The Honourable David Cunliffe.
Thank you, sir. Sir, in terms of the commencement date of this bill, I wonder, sir, whether it would be appropriate to have a commencement date 3 days after it should have taken effect. Because what has occurred here, sir, is a rally of technicians against a boycott which was actually lifted 3 days earlier, sir. And what is clear, sir, is that parties knew that. The government knew that. Peter Jackson knew that. Warner Brothers knew that. And a fictitious protest occurred, sir, 3 days after the boycott was to be lifted. 3 days. And Mr Chairman, that is relevant to the commencement date because a 3-day gap between when something should have taken effect and when it actually did take effect would thwart the purpose of the Act. Thwart the purpose of the Act, sir. And moreover, sir, it would be false pretences, sir. False pretences is the basis of a protest about a boycott which had already been lifted.
Order. I will not mention to the member again This is about the commencement. It's a very narrow scope. If the member deviates again, I'll terminate his speech. He has 1 minute 20 remaining. This is the commencement date. Honourable David Cunliffe.
Mr. Speaker, this bill should not commence on its commencement date. It should not commence at all. This bill is unnecessary, just as rallies were unnecessary about a boycott which did not exist at the time. This bill should not commence because there is and was no substantive employment dispute that this bill is designed to fix, because this bill is about wedge politics. It's about dog whistle politics for certain bottom-dwelling members of society that party wants to lock up as national voters and turn against workers. It was a fictitious bill.
I have a point of order here by David Bennett.
That's what I'm trying to draw to
The Speaker's gone off the commencement date
I will determine the relevance. That's not necessary. The member has 30 seconds remaining.
Mr. Speaker, this bill should not commence. As my colleague Trevor Mallard has said, and as Jerry Brownlee said in answer to questions today, this bill changes nothing because there was no substantive problem. The court case to which it refers, in terms of timing, sir, was in 2005. 2005. This bill should not commence. It should not commence because it is a political artifice. A political artifice designed to polarise New Zealanders against other New Zealanders.
I call Catherine Delahunty.